Welcome, dear students, to our history class of Standard 9th. In our previous video, we have learnt about movements which displayed strong leadership of women. In this part, we shall discuss about the laws for women and weaker sections. Laws for women. Alimony. The happiness of marriage comes with a whole lot of responsibilities. The husband is required to take care of the wife for a lifetime, as the law imposes a moral obligation on him to do so. But when things fall apart, both the spouses decide for the dissolution of marriage, for this relation being a quagmire. One cannot just end this sacred alliance so easily, because the responsibilities are still there to comply with. A man is obliged to provide the allowance for the sustenance of his wife and child. The conditions where a woman is not able to maintain herself can claim for the financial support from the husband. This financial support can be provided particularly scheduled payments, or the amount can be given in lump sum amount, that is, alimony. Share in father's property. According to existing laws, a daughter has the same right as a son over the property of a father. Stridhan. As per Hindu law, Stridhan is whatever a woman receives during her lifetime. Stridhan includes all movable, immovable property, gifts, etc. received by women prior to marriage, at the time of marriage, during childbirth, and during her widowhood. Women have an absolute right over their Stridhan. Dowry Prohibition Act of 1966. Dowry includes property, goods or money given to the marriage by the parents of either party. Dowry Prohibition Act is an Indian law enacted on 1st May 1961, intended to prevent the giving or receiving of a dowry. This dismantled the dowry tradition by its roots and further encouraged the social movement. The law alleviated the distress to women caused by the undesirable tradition of dowry. Maternity Benefit Act of 1961. The Maternity Benefit Act of 1961 protects the employment of women during the time of her maternity and entitles her of her maternity benefit, that is, full paid absence from work to take care of her child. This act is applicable to all establishments employing 10 or more persons. Awareness against dowry tradition. Even after the enactment of anti-dowry law, incidents like woman burns to death as sari pallu catches fire while cooking, and woman slips into well while washing clothes, and drowns and dies, continues to be reported. Investigations still reveal dowry to be the most frequent cause of such deaths. The role of the police, the administration, and judiciary were highlighted. This created greater awareness. As a result, the Dowry Prohibition Amendment Act came into force in 1984. In 1988, 2,209 women died victim to the dowry tradition. In 1990, the number of dowry deaths was 4,835, and in 1993, it was 5,377. These numbers will impress upon you the seriousness of the issue. Family Courts. In 1984, the Family Courts Act was passed and it came into force on September 14, 1984. The objective was to take family and marital disputes away from the overcrowded, intimidated and congested environment of traditional courts of law and bring them to congenial and sympathetic surroundings. The purpose and aim of establishing the family courts is to protect and preserve the institution of marriage and to promote the welfare of children and provide for settlement of disputes by conciliation. The aim was conciliation between the estranged family members and not confrontation. Trial involving alimony, 1985. Shah Banu Begum, who belonged to Indore, Madhya Pradesh, was divorced by her husband in 1978. She filed a criminal suit in the Supreme Court of India in which she won the right to alimony from her husband. However, the Muslim politicians mounted a campaign for the verdict's nullification. The judgment in favor of the woman in this case evoked criticism among Muslims, some of whom cited the Quran to show that the judgment was in conflict with Islamic law. It triggered controversy about the extent of having different civil codes for different religions in India. Subsequently, the Parliament of India in 1986 decided to enact the Muslim Women Protection of Rights of Divorce Act in 1986. Roop Kanwar's Sati in Rajasthan had become a national controversy and the government had been sharply criticized for not condemning it and taking timely action. A corpse being burnt on a funeral pyre is a gruesome spectacle. Even the staunchest are often unable to bear the sight and turn away. But hundreds of villagers of Deorala village in Rajasthan's Shikhar district who watched the Sati burning of a live 18-year-old Roop Kanwar along with her husband's corpse saw nothing horrific. Once the ceremony is over, the sacrificed woman is consecrated as a goddess and the funeral spot becomes a shrine. Henceforth, no one can refer to her by her name. She is either Satiji or Sati Mata, immortalized for her balidan and courage. Roop Kanwar's turning Sati was greeted with shock across the nation, but for local villagers, Deorala became a place of worship overnight. The scathing public criticism finally forced a paralyzed Rajasthan government to act, even if belatedly. The Commission of Sati Prevention Act of 1987 prohibits the construction of temples in the memory of someone who has committed sati and empowers district magistrates to remove them, whereas sati or the burning or burying alive of widows or women is revolting to the feelings of human nature and nowhere enjoined by any of the religions of India as an imperative duty, and whereas it is necessary to take more effective measure to prevent the commission of sati and its glorification. The Human Rights Act 1993 is aimed at giving all people equal opportunities and preventing unfair treatment on the basis of irrelevant personal characteristics. The Human Rights Act covers discrimination on the grounds of gender or marital status. It also deals with collective oppression, the social conditions of divorced women, women and secure places, played an effective role in mitigating injustice to women. The National Human Rights Commission was also formed for this purpose. The 73rd and 74th Amendments to the Constitutions provide for reservation of one-third of the seats for women in Gram Panchayat Samitis, Zilla Parishads, municipalities and municipal corporations, as well as for the posts of Sarpanch, Chairman and Mayor. Maharashtra and 15 other states have reserved 50% seats for women. This provision provides women the opportunity to participate in the business of the community. Scheduled castes. Our Constitution adopted the values of freedom, equality, fraternity, and social justice. In accordance with this, the practice of untouchability was banned by law. In view of the educational and social backwardness of scheduled caste, they were given reservations in education as well as jobs to facilitate their development. Adivasis who live in remote parts of the country face several difficulties. As they have lived far away from the progress made in modern times, they are economically and socially backward. Even though their conditions have seen some improvement in recent times, they do not have means of livelihood other than agriculture and forest produce. Modern farming implements have not yet reached them, hence their income from agriculture is very small. Besides, their fields are on hillsides and not fertile. They are malnourished due to insufficient and poor quality of diet. Adivasis in remote areas find it difficult to get medical attention in time. For all these reasons, there is a need to give special protection to Adivasis. In the Indian Constitution, Adivasis have been enumerated as scheduled tribes. They are getting given representation in law boards, education, government services, etc. Castes and tribes that move from place to place for livelihood are included under nomadic tribes. During colonial rule, the Criminal Tribes Act of 1871 vilified several nomadic tribes as hereditary criminals. Addicted to systematic commission of non-bailable offences, the prevailing caste system's rationale was used for such categorization of these communities. These communities were subjugated to state surveillance, control and violence in myriad ways. The Criminal Tribes Act of 1871 was repealed in 1952, following the adoption of the Indian Constitution. However, many denotified tribes continue to face the taint of criminality. The police, courts and society continue to view them as criminals. They are default suspects in cases of theft and dacoity. These communities also find that traditional occupations criminalized through excise laws, wildlife conservation laws, cattle slaughter prohibition laws. Members of denotified tribe communities constitute a majority of people prosecuted under these laws. Special efforts are being made by the government for the purpose of their social and economic development. These tribes have been given representation in educational institutions and in government sector. An ethnic, religious or linguistic minority is any group of persons which constitutes less than half of the population in the entire territory of a state, whose members share common characteristics of culture, religion or language, or a combination of any of these. Minorities often face discrimination and exclusion, and they struggle to gain access to their human rights, even under the conditions of full and unquestioned citizenship. There are 6 religions in India which have been awarded national minority status, that is, Muslims, Christians, Sikhs, Jains, Buddhists, and Zoroastrians. Article 29 protects the interests of the minorities by making a provision that any citizen having a distinct language, script or culture have the right to conserve the same. Article 29 mandates that no discrimination would be done on the ground of religion, race, caste, language or any of them. For this purpose, they have the right to set up separate educational institutions. The government implements various schemes for their progress. So dear students, we see today that due to these provisions, women and weaker sections have begun to get education and to earn. Also, due to the ideas of women's liberation, women are developing a sense of self. They have begun to participate enthusiastically and with determination in all fields of education, earning money, administration, politics, etc. In the next chapter, we shall learn about the progress that India has made in the field of science and technology in the post-independence period. That's all for this class. Thanks for watching.